Hello, I greet you all, my ardent viewers and treasured, most esteemed listeners and watchers. We are back again on your favorite channel, Human Rights Heralds, with your usual anchor, Ogochukwu Onoha, the Human Rights Wizard. Welcome to episode 12 of Human Rights Heralds. A half hour with your Human Rights Wizard. I am glad to know that you are in my company once again as we continue our historic journey to empower our people to be able to defend, to be able to know, to be able to protect, and to defend their rights, as well as accord honor and observance to the rights of other people. All of this pursuant to evolving an orderly and harmonious society where we can all beat our chest and say, this is our country and we have arrived and we have made things and put things in place in ways that will be favorable to all of us. In this episode of a half hour with the Human Rights Wizard, we'll be talking about the Labor Act and the rights of workers. The Labor Act and the rights of workers. Are you a worker? I am sure the answer is yes. Everyone alive is a worker, one way or the other, directly or indirectly. We all work in our families as children, as mothers and fathers. They are all examples of employment. But in our discussion today, we'll be talking about the formal employment that has to do with an entrepreneur, a business entrepreneur, whom we will refer to in this discussion as the employer. The usual term for such a business entrepreneur is the employer, the legal term. And then the worker, we shall be referring to intermittently as the employee and the worker. If someone has engaged another to provide services for him or her for a given consideration, in this case, for a given sum of money, then it is said that there is a contract of employment between the two parties. I'll need to refer you to our 10th episode video captioned Tenancy and the Law of Contract. You need to watch that video to understand what I mean by a contract of employment between an employer and the employee. Let us take a look at some of the nitty-gritties of the contract of employment. The employer contracts to pay the employee a certain amount of money. The employer has the right to choose to employ or not to employ, and to choose who to employ and who not to employ. The employee reserves the right to accept the offer made by the employer or to reject it. The employer reserves the right to be respected by the employee. The employee reserves the right to be accorded dignity by the employer in their work relationship. The employer reserves the right to decide the condition of service attached to the job the employee reserves the right to accept or to reject the condition of service offered by the employee. The employer reserves the right to make regulations regarding the condition of work, regulations concerning late coming, the regulations regarding the duration of work, the time of dismissal, time of commencement, and so on and so forth. The employee reserves the right to accept or not to accept some or all of the provisions of such a regulation. Having started the job, if the employee is found culpable of some criminal offenses in the field of work, that is, if the employee is accused or is suspected of having committed some criminal offense while performing his job, the case must be decided in the National Industrial Court of Nigeria, or Nigeria's National Industrial Court, before a punishment can be meted out to the worker or employee. The worker himself also has the right to appeal at the High Court against any decision reached on such a matter by the National Industrial Court. The employee or worker has the right to make demands concerning working hours, the duration of work, and to make demands concerning days of rest during the week and allowances for transportation, for feeding, and similar benefits that have to be attached to the job. Now, this gives us the background to the discussion that we are having today. Now, let's talk about some legal instruments in Nigeria. Some legal instruments that border on the rights of workers. The first is Section 33 of the Constitution of the Federation of Nigeria, 1999, as amended. Section 34, is on right to dignity of human person. It implies that the worker reserves the right to be treated with all the honor deserving of a human person, all the honor and respect that a human being deserves. Then Section 36 of the same Constitution is on the right to fair hearing. So in the event of an industrial dispute involving the employee or the worker, the employee or the worker reserves the right to be heard. He or she reserves the right to have the dispute heard at an appropriate court level and be allowed to present his or her own side of the dispute before a decision can be reached on it. Then Section 40 is on the right to freedom of peaceful assembly and association. It implies that the employee or worker cannot be forced to work. Therefore, it outlaws forced labor. No one must be forced to engage in a productive employment against his or her will. So the employee must decide to work or decide not to work. No one or authority must compel him or her to work against his or her will. That section of the Constitution outlaws slavery, so no one can be made a work slave. It outlaws forced sex work. It outlaws forced sex work. Therefore, the members of the female gender or the male gender must not be trafficked within Nigeria to a destination where they will engage in sex work in order to produce income for their owner. That is against the freedom of peaceful assembly and association. Then finally, Section 42 is on right to freedom from discrimination. Employees or workers must not be discriminated against on any ground, not on the ground of gender, not on the ground of tribe or ethnicity, not on the ground of religion, not on the ground of clannishness or tribesmanship, as the case may be. There are cases in Nigeria where some female workers are denied promotion just because they have refused to offer sex to their employees. That is an infringement on their rights, on their right to freedom from discrimination. In some other cases, female workers who perform the same measure of job as their male counterparts are paid lower only on the ground that they are female. This is also a discrimination against the female workers and is not permissible in the law. And then in places in Nigeria, some laborers are hired and promoted rapidly because of the part of the country they hail from, while others remain stagnant on their job, denied promotion also because they are not from a named part of the country. This is against the right to freedom from discrimination. Now, the other legal instruments in Nigeria that affect the rights of workers is the Labor Act. I must add quickly that the Labor Act and the rights of workers is a very large volume of documents that we cannot discuss within a short period of time as we have today. Therefore, there will be subsequent videos that will come after this, where we will discuss other aspects of the Labor Act. We can only take a small part of it today, focusing squarely on the rights of workers. So let's talk about what the Labor Act provides. The Labor Act is a legal instrument in Nigerian law, an act of the Nigerian Parliament or Nigerian National Assembly that provides for the rights of workers, the rights of employers in their relationship with their workers. Let us talk about the first section of that act. This section has to do with the remuneration. Remuneration means payment for work done. It says that all payment for labor performed by workers must be in the approved legal tender. That means workers must be paid in the money, the official money used in Nigeria, in which case the naira. Therefore, it is against the law for Nigerian workers to be paid in US dollars or in the British pound sterling or in some other currencies that are not legal tender in Nigeria. And then that same section goes on to say that payment of workers in any other mode or manner except in the legal tender, the official legal tender, is null and void. Section 2 provides that in certain circumstances, the employer is allowed to provide a dwelling accommodation, that is a living place for workers, provide them with food and drink as a part of their payment, not the entire payment, as a part of their payment, that is the legal tender or money paid to the worker, along with provision for accommodation, a provision for an official canteen or office canteen where the worker can eat, a provision for transport allowance, a provision for sick leave or medical facility or clinic at the place of work, a provision of drinks along with the salary which the worker receives is acceptable in the law, provided it is a part of the contract of employment that the worker signed while negotiating his employment. But on no account is an employer allowed to provide intoxicating liquor for his workers. When I say liquor, I mean alcoholic beverage, or we can use the word spirit, to provide spirit or alcoholic beverage for the workers, or to provide drugs like heroin or marijuana or cocaine or Indian hemp, as they are variously named, as a part of payment for workers. This is against the law, except when otherwise provided in the employment agreement or contract of employment. The employer is to pay the worker or employee only in the legal tender. But if the contract of employment so provides, then the worker can also be paid by check or by postal order or some other such arrangement that does not involve cash payment in the legal tender will also be acceptable. Now, let's talk about Section 3 of the Labor Act. Well, we've talked about Section 1. Section 1 deals with the employer not paying the employee in any other medium except the legal tender. And Section 2 says the employer can pay in kind along with money. Kind means food, dwelling place or accommodation, or office canteen, transport allowance, provision for office clinic, and other such arrangements apart from the money. That we are told, while providing nourishment, including drink, it must not include spirit or alcoholic beverage, and then hard drugs like heroin, marijuana, and all of them. Then Section 3. In no condition must the employer decide where and how or in what manner the employee is to spend the salary that he has earned from the employer. So the employer must not decide that you have to spend your money here or there or in this manner. That decision is left to the employee. That is Section 3. Then advance payment. Workers normally refer to this as a work loan. You want to get a loan, it's called a salary advance. You find yourself in a financial difficulty and you want your salary paid in advance. And the provision of the Labor Act, that is Section 4 of the Labor Act, provides that no employer must pay an employee an advance payment that is more than his monthly salary. So if a worker's monthly salary is 100,000 naira and he is in need of money when his salary is not due, the employer can give him a salary advance, but the salary advance must not be more than the 100,000 naira he earns. Then a second subsection of that Section 4 provides that the repayment of a salary advance must be done within a minimum of 3 months, but not below that. I would like you to understand what this means. If a worker borrows money, which is a part of his salary advance, the repayment must be done within 3 months, or a period, but not a period lower than 3 months. The payment can be spread within 3 months, or more months, but not below 3 months. That is what that means. Then, A third subsection, that is subsection 3 of section 4, provides that there mustn't be any kind of discount or interest that the employer would charge on the amount of advance, on the actual advance he has lent to the worker. So what the worker repays the employer is simply the amount borrowed, the amount of the advance or the amount of the loan, but not anything more than that. So the employer is not allowed to add charges like discount payment or interest on the amount borrowed. Then, no deduction whatsoever, subsection 4, no deduction whatever must be made on the salary of a worker without his consent. Deductions like trade union dues can only be made if the worker has in writing stated that he wants to pay or he wants to be making such payment from his salary, being a member of the trade union. Of course, trade unionism and its membership are also regulated by law. Read section 40 of Nigerian Constitution. So that is that. Now, let us take a look at some of the rights of workers which are sometimes violated by employees. By employers, I beg your pardon. First of all, in Nigeria, many employers deliberately refuse to allow the worker to sign an appointment paper. In our next video, we shall be discussing the appointment paper in detail, talking about its content. But today, it is enough for us simply to mention that some employees refuse to allow workers to sign the statutory appointment paper where the conditions of service are spelled out. And by doing so, they are free to treat the workers just in ways they deem necessary, often to the detriment of the workers. Then, secondly, dismissal of workers. Sometimes workers are dismissed illegally, often in ways that are not approved by the law. Sometimes because the worker is vocal against some of the maladministration affecting the rights of workers that he or she has noticed or has been a victim of in the organization. And then, assault of workers. Yes, there are employers who are audacious enough to slap or even beat up a worker on the field of work. This is an infringement of the worker's right to the dignity of human person. Then, thirdly, sexual harassment, especially against female workers. But we know of female chief executives that insist that their drivers must have sex with them, otherwise the driver will be dismissed. That is sexual harassment. And male chief executives that regularly have sex with their secretaries, with their female secretaries, as a condition of employment, otherwise the secretary will lose her job. This is also an infringement on the right to the freedom of choice of such a female secretary. Then, of course, like I pointed out earlier on, dismissal of workers, illegal dismissal of workers without prior notification is also an area where the rights of workers are trampled upon by employees. Deduction of workers' salaries. Workers very often use the term surcharge. The Labour Act provides regulations on how a worker is to be dismissed, how a worker is to be fined if the worker violates some of the rules in the contract of employment. For instance, I have witnessed an employer who deducts as much as 10,000 naira from a worker's salary just because the worker has been to work late a number of days in a month. And then failure to attend a meeting in the organization makes a worker lose a part of his or her salary. This is injustice. And organizations where workers are prevented from unionizing, from forming workers' union, and any worker who is known to engage in just a discussion about unionism is dismissed without notice. This is an infringement on the rights of workers. So in our discussion today, we've been talking about the Labor Act and the rights of workers. There is so much to be said on this topic, but like I have said, in our 2 or 3 subsequent videos, we will still be talking about the Labor Act and the rights of workers. Today we have hinted on some rights of employees and some rights of employers and some areas where employers often trample on the rights of workers. On our next video, which I'm inviting you to attend, we'll be talking about the business models, some business models in Nigeria that are established for the simple purpose of exploiting workers and denying them of their industrial rights. Until we meet on that next video, remember the purpose of this channel: to educate you on your rights in the law so that you become a law-abiding citizen capable of knowing your rights, protecting your rights, and defending your rights, and in so doing, impact positively on other citizens by respecting their own rights and educating them also on how to go about protecting their own rights and respecting the rights of others. You can do this channel a favor by liking this video, sharing this video, and subscribing to this channel so as to encourage us to give you more videos of this kind. Without your active collaboration in the dissemination of our videos, we will not be able to make a lot of impact. There are many people out there who need the information contained in this video, but who may not be able to access it unless you assist in its dissemination. So I ask you to like this video, give this video a thumbs up, and share the video so that others will join in reaping the benefits that it has to offer. Until I see you again or meet you again on our next video, know your rights, protect your rights, and defend your rights. Remain law-abiding and stay out of trouble. Bye-bye.